agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal. And it looks like the agreement that you've reached is for a cap of
50 years. That's the kind of number that instantly makes the courtroom go silent. Imagine sitting there while the rest of your life is weighed in decades.
Division of the Texas Department of Corrections. I want to make sure you understand your case is set for trial next week. You have every right to go forward and have a trial, and a jury decide two things. The first is to decide if you're guilty or not, and then you could leave your punishment up to them if you're found guilty.
This is a crucial legal moment. By waiving the right to appeal, the defendant is putting complete trust in the judge's sentencino. Second chances, no dovers.
By going forward this way, you're waiving that, and you're leaving it up to me. As long as I give you 50 years or less, then you're waiving that right to appeal. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State Tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. James is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done by probation. Anything that you think is important for me to know, get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. And we'll see you at that sentencing hearing. You can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Your Honor, we did have a scheduled hearing at 11 with witnesses. I'm not going to need to call witnesses today.
Okay, let me take care of the rest of what we got, and then we'll get to it in just a minute. And is Todd LeBlanc back there working on something?
He texted him, he has an answer.
Todd LeBlanc in the back?
With Roberto Armenta,
Uh-huh.
and I've been informed that his family's actually retaining someone for him.
Okay.
So he was just gonna need time so they can finish getting that in.
We're going to reset Norberto Armenta to hire a lawyer. Thank you, Mr. Lewis.
No problem.
Ms. Holmes, you have Jamarcus Zarate Jones.
I'm going to be more complicated. They're doing a dismissal of the state's motion in that case to revoke. We have an agreement, we need paperwork on this, for a 30-day sanction of the defendant and continue on probation. The underlying criminal offenses have been either refused or dismissed. And then there is a criminal offense from Harris County that I've not been able to determine.
I've been informed that will be disposed of as well with the dismissal, but it has not happened yet.
Okay, so I will sign the motion to revoke dismissal as soon as it comes through. I will order the 30 days upfront time, or 30 days as a sanction, as the agreement that he gets credit since he's been in custody on this. Okay, all right, we'll get that done. And probation, if I need to sign something, I can get that signed today for the 30 days. All right, good luck. Make sure you're on probation, follow all of those rules and conditions, or you're going to end up right back in here. Okay, you're free to go back with the bailiff.
I'm doing that.
Okay.
Let's see, Jordan Thomas, yes ma'am.
I have filed a request to reduce bond.
Jordan Thomas.
It's Kobe's.
It's Mr. Hoffpower's case.
Yeah, he said he's gonna dismiss the TRP. It's, I found a motion to respond on one of the sexual assault.
But I think
I talked to Kobe.
grab him, because I'm.
Okay, I'll hold it till he comes back in.
Yeah, I talked to him.
Oh, you did? Okay, good, thanks.
Who's Andre Williams? What am I missing? I have a plea bargain rejection up here, but I don't have, all my pages are full up like I've got. Andre Williams? Bless you, bless you.
Joel. Maybe he did on that, we already took care of it.
I did reset them, so I don't know why. I'll just delete it. I
Wanted, think about discovery stuff.
don't know why he did that.
No.
I'm gonna delete that.
We had to do it with people.
Okay, yeah. So I think, all I show then is Jordan Thomas and then the one that they have at 11, I think.
And I'm trying to find out about.
Todd LeBlanc, yeah.
So this is how old her cousin is on that rig. I don't know if the system will pull it up. I mean, I was here when that cousin was done.
Or any health members have ever been in a what?
I mean, can we put it on the tablet for this Judge Brandon read? That might be the DA number.
I was thinking about that case y'all had last week, you had a mistrial. How horrible they are, you gotta do it again. I don't even know the facts, but I know it can't be good.
What am I doing? What am I doing? Jordan. All right, are you ready on Jordan? Well, now where'd Miss Holmes go? Is Brittany in the back?
I'm ready.
We're good.
She went outside somewhere.
All right.
Mine's agreed pretty much. 11 o'clock.
Okay, hold on. Theodore Briscoe, MTRP sentencing.
Hey, Luke. He's signing us right now for the,
Just tear it up.
Wanted of that. I was gonna say, she didn't put it in wanted.
Langston is. We're good.
All right, sir, are you Theodore Briscoe?
Yes, ma'am, I am.
And Mr. Briscoe is on probation in cause numbers 20-34535 and 20-36055. Motion to revokes were filed in those. They're both deferred probations, one for possession of a controlled substance, the other for evading arrest or detention with the use of a vehicle. Mr. Briscoe was previously in court, entered pleas of true to counts 1, 4, and 5. We reset this for a hearing. I have received the pre-sentence updated report. Has everyone received that report?
We have, Your Honor.
Yes, we have, Your Honor.
And go ahead.
I'm just going to let the court know, after reviewing the probation officer's report, I'm in agreement with the recommendation of ISF. I don't see a problem with that based on the information provided.
Okay. And no witnesses or with regard to any of the other
Not going
counts?
to need to, Your Honor. He pled true to one concern is that there is a drug offense pending that's not yet been filed, it's still awaiting testing.
Okay.
We'll try to catch it as soon as we do, and either run a concurrent or we'll deal with it. It just hasn't been brought to us yet.
Okay.
There's misdemeanors pending that
He's
we've
taking
discussed.
care of it.
He's going to take care of it
License here.
as soon as he is done here, they'll free him up to be sent off.
What I'd like to say, just on his benefit, there was a charge of the possession of a controlled substance, and there was a pack of cigarettes that he picked up, and he says he picked up the wrong pack of cigarettes. It was a female that I think lived with him at the house, and they had issues. He had tested clean for 3 years, I believe, or for some time, And it was even tested a couple of days after this. And he said he picked up the wrong pack of cigarettes. She had been trying to get him in trouble to get rid of him. So just, not that it has an impact on this, but that's,
Okay. Well, sounds like if somebody's trying to get rid of you, you just need to leave, right?
Go.
Okay. All right, Mr. Briscoe, I'm going to find that you previously entered your pleas of true to counts 1, 4, and 5 in each of your cases, freely and voluntarily. Find those counts true. Find sufficient evidence to revoke both of those probations, but I'm not going to do that. It sounds like probation is willing to work with you and that they have reason to believe you can be successful. So I am going to extend your probation for 2 years. You will be ordered to enter and successfully complete the cognitive track of the Intermediate Sanctions Facility, the ISF program. You'll be on the high medium caseload and be required, obviously, to follow all of the rules and conditions of probation when you get out of ISF. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
I congratulated Burbank on, he's always stressing me, so I said, congratulations on getting a guy to jail time. But you had probation on one of the cases here.
Oh,
He's like, oh, thanks.
uh-huh. Here's that.
Sorry.
Okay, Jordan Thomas. Okay, are you Jordan Thomas?
Yes, ma'am.
And Mr. Thomas is charged in cause number 24 DCCR 0487 with sexual assault of a child, and in cause number 24 DCCR 2178 with aggravated assault with a deadly weapon. And Ms. Holmes filed a motion to reduce the bond. Is that an...
Notice how calm and respect Thomas sounds. Judges care less about tone and more about past act, and his record is about to catch up.
Each of his cases,
And just the sexual assault.
which is $100,000 in that case presently, and I know this was recently filed. Mr. Hoffpower, are you ready to proceed on that, or do you need time?
We'll need time.
All right, Ms. Holmes, do you intend to call your client?
Yes, sir. Yes, ma'am.
Mr. Thomas, please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You may proceed.
Thank you. Your name is Jordan Thomas, correct?
Yes, ma'am.
And Mr. Thomas, how long have you been incarcerated at the Jefferson County Correctional Facility?
9 months.
9 months. And in those 9 months, has your bond been set at $100,000 for the offense of the sexual assault?
Yes, ma'am.
And has your family during that time tried to inquire about helping you make bail, but have been unable to due to the
This right here is where Thomas loses ground. In court, excuses matter, and saying nothing is often worse than admitting fault. What would you say if you were in his shoes?
Yes, ma'am.
and do you have any property at this time or anything of value that you could sell that could arise to the amount to be able to bond out at $100,000? Okay, and have you all worked diligently within these 9 months to try to get that done but have not been able to?
Yes, ma'am.
And are you asking the court to reduce your bond in an amount reasonable, and that you will abide by any conditions, and also whatever court appearances that you will be present, and that you will not be a flight risk?
Yes, ma'am.
So there was a bond forfeiture for non-appearance. That's why it's at $100,000 back in June of 2024. Why'd you miss your court date?
You got no answer.
Okay, you just didn't feel like getting up and coming? I mean,
No,
so
not-
she's
that's
asking
too,
me
I
to
didn't have
reduce,
transportation either, but,
I can't hear you.
I had transportation. I stayed home for. I tried to come, but
Did you call anybody? And
I called the bell. I called the bell phones company. I told them probably wouldn't make it. They told me to, turn myself in. So, the day of court, they wanted me to turn myself in
right.
after I missed the.
And Harris, the big red flag prosecutors highlight that while Thomas was already out on bond, he allegedly picked up another violent charge. For a judge, that's almost an automatic no to bond reduction.
court there.
Okay, so why didn't you, when did you do that?
I believe I
Did
turned-
you turn yourself in or were you
No, I
arrested?
turned myself in.
When?
December 19th.
So you decided between June and December, you would just kind of hang out and see if anybody caught you knowing there was a bond forfeiture?
I didn't know it was a bond for.
Well, if you don't show up for court, you don't get to just not show up for court and not have any consequences and just chill out and wait till whenever, right? Mr. Hoffpower,
I don't have any questions, it's just an argument.
what's your position?
My position, in light of 17.15, danger to community, just on the original charge, which we're here today on sexual assault, I think the bonds would be high sufficient because of, due to the allegations and due to the danger of children in the community. Also, I want to add, obviously the court knows there's another case that is before the court in yours, and it is another serious, dangerous felony. It was committed while he was on bond and in bond forfeiture on his sexual assault case. So that he proves my point.
So
I know it's like similar actions, but it is.
the offense date on the aggravated assault with a deadly weapon is from August of 2024. And so, hold on, when was the bond forfeiture?
June.
July.
No, you said June, July.
June of
I
2024.
don't know why he wasn't arrested. He was arrested, or I don't know,
Why,
Okay.
because the police interacted with him.
there
that
should have
night.
been a forfeiture and a warrant on the other case at that time as well.
Yeah.
So while you were out on bond is when this new allegation allegedly happened. Let me look at the PC on that one as well real quick.
August 18th.
Oh my gosh, I can't find anything on here. There it is.
Public safety outweighs
There was a
Domas'
warrant.
request
This,
for free
I
and
don't
firm,
think he was
fair, and
arrested.
fine.
This shows Capia's return was from December, so that's when he turned himself in, probably on both of them.
I apologize if
Yeah.
I represented something different.
No, I'm just saying, I don't think he got, I think that's, hold on a second, I can't read this, I gotta print it out. I'm printing the PC.
Oh, yes, on the plus.
Okay. Your motion's denied. Based on the fact that you were out on bond and allegedly committed this offense, which gives me some concern, which is the aggravated assault with a deadly weapon, and you missed your court date and really have no good reasons why